Good day. This presentation talks about Chapter 8, which is the unenforceable contracts. This chapter conveys Articles 1403 to 1408. Before proceeding with Article 1403, let me first introduce the unenforceable contract. An unenforceable contract is a valid contract such that the essential elements of a contract are present, such as consent, object, and cause. However, the status of the said contract is not enforceable to the court. Their contract is not binding for certain reasons, such as due to a lack of evidence supporting the existence of the contract, because one party to the contract acted in bad faith and took advantage of the other, or incapacity of both parties that the said contract may have the defect. Until and unless they are ratified legally, contracts that contain certain defects are determined by law. Let's proceed to Article 1403. Article 1403 states the kinds of unenforceable contracts. There are three kinds of unenforceable contracts. The following contracts are unenforceable unless they are ratified. First, those entered into the name of another by one without or acting in excess of authority. For the first kind of unenforceable contract states the definition of unauthorized contract. For a deeper discussion, this statement will discuss further to understand unauthorized contract sounder. Second, those that do not comply with the statute of frauds. The overview of the statute of frauds for this paragraph must be in writing by the following item listed in the slide in order to be enforceable. However, if the statute of fraud is not in writing and is made orally by the following contents, it will be unenforceable. Therefore, in order to prevent fraud and mistakes, the statute of frauds mandates that some contracts be put in writing. Such as the following listed, we'll discuss later on further for a deeper understanding in regards of the statute of frauds. In addition, take note that there is an exception concerning the statute of fraud. If the party partially executed the contract, the statute of fraud will not comply. The third kind of unenforceable contract is both parties are incapable of giving consent. Hence, if both parties cannot fulfill because of their inability of provide consent, it shall not be enforceable.
To start, let me introduce the Statute of Frauds. The Statute of Frauds basically deals with certain types of agreements and is a legal doctrine that requires a contract to be in written form between parties for it to be legally enforceable. It covers everything related to the purchase and sale of property or goods over 500. And if you ever need to pursue legal action over a property, you'll need to have a written contract signed by the other party to prove everything. Now let's have a little background on the history of the Statute of Frauds. In 1677, a rule was ordered to counter malicious act of giving misleading declarations, particularly in agreements. By enacting the Statute of Frauds, misleading agreements are said to be unenforceable unless they are proved in writing. Next is, its purpose was to simply prevent fraud or rather injury to an involved party. Lastly, the statute of frauds doesn't have a strict manner wherein it will require a specific format or more. It can be embodied in a slip of paper in the form of a letter, note, or memorandum by means of a pen or a pencil or any mechanical device as long as this is understandable and coherent with the expectation and knowledge of the parties.
The fourth one in the statute of fraud is the application. Four sound fundamental principles relative to the statute of fraud are given. The first application is that the statute of fraud is not applicable in actions which are neither for damages because of the violation of a contract nor for their specific performance. The next application is that it is applicable only to completed statutory contracts or no performance has been made by the both parties and not to contracts which are totally executed or contracts is partial performance. The reason is that the partial performance, like writing, furnishes reliable evidence of the intention of the parties or the existence of the contract. The next application is it is not applicable where the contract is submitted expressly or impliedly by the offeror to deny the specifically existence, no further evidence thereof being required in such case. Fourth application is that it is applicable only to the agreement enumerated earlier. In this application, it is an agreement creating an easement of right of way is not covered by the statute since it is a sale of real property or of an interest therein. If application is it is applicable where a writing does not express the true agreement of the parties. This is because this statute cannot be used as a shield for fraud or as a means for the perpetration of it. Its application is that it does not declare the contract infringing it or void but merely enforceable. Second application is that the defense of the statute of fraud may be waived. And the last application is that the defense of the statute of fraud is personal to the parties that cannot be interposed by strangers to the contract. There are two illustrative cases given under the statute of fraud. The first case is verbal contract of sale of land is used to show the lawful possession of the applicant and citing them to have their title directly registered. The statement given in this case is Heck, etc. presented evidence that they have been in the possession of the parcel of land in the question since the year 1912 when Y before his death delivered to them said land pursuant to a verbal contract of sale for the price of 1,500 payable by installment, of which X, etc. had been paid to Y 500, and the latter delivered to them the documents pertaining the land and that since their possession and for them that of Y under the claim of ownership had been exclusive and continuous, they were entitled to have their title over said parcel of land registered as applied for the registration proceeding. The question is, may X, etc. introduce evidence of the valid verbal contract of sale? The answer is yes. The contract was not covered by the statute of fraud because the contract was partially executed. Furthermore, the verbal contract was adduced not to purpose of enforcing performance thereof, but as the basis of the lawful possession of the applicants, X, etc., entitled them to have the land thereby sold, registered in their own name. The second case is verbal agreement sought to be enforced referring not to sale but to promise to convey real property for services rendered. The statement given in this case is company X owing as a cause of action in 1953, the defendants availed themselves of the services as intermediary with the bidders to work for the amicable settlement of the civil case in that. The question is this statute of frauds applicable? The answer is no. It is elementary that the statute refers to the specific kind of transactions and that it cannot apply to any that is not enumerated therein. In the instant case, what X is trying to enforce is the delivered to him of 3,000 square meters of land, which is claims which he claims defendant promised to do in the consideration of his services as mediator or intermediary in effecting compromise of the civil case between the defendant and the bidders. In no sense may such a legal contract may be considered as a being sale of real property and interest therein. Indeed, not all dealings involving interest in real property come under this feature.
The next topic is agreement within the scope of statute of frauds. Agreement not to be performed within 1 year from the making thereof. Under the Philippine law, an agreement not to be performed within 1 year is subject to the requirements of the statute of frauds. This means that the agreement must be in writing and signed by both parties in order to be enforceable. The written agreement must also clearly state the terms of the contract and the time frame of the performance. Example: on October 10, 2018, S entered into an oral contract with B for the construction of B's house to begin on October 20, 2019. The contract must be in writing to be enforceable. If the contract cannot be completed within a reasonable time frame, it may be considered void. For example, if the contract is for a project that is expected to take more than a year to complete, it may be unenforceable unless the contract contains provisions for extension or delays. Next is the promise to answer for the death, default, or miscarriage of another. This type of contract is also known as a surety agreement or a guarantee agreement, and it involves a third party called the surety promising to be responsible for the obligations of another person called the principal debtor. This means that if the surety agreement was drafted by the creditor and the surety had no opportunity to negotiate or modify the terms of the contract, the surety may have certain rights and remedies available. Example, DOC 50,000 pesos with G as guarantor. Here, G has a special promise to answer for the debt of D in case D fails to pay the same. This promise is unenforceable unless it is in writing signed by G. It is important to note that in guarantee, the promise is merely subsidiary or collateral to the promise of another. If the promise is an original or an independent one, that is, if the promisor or surety becomes thereby primarily liable for the payment of the debt, the promise is not within the statute and may be proved by oral evidence.
Agreement and consideration of marriage other than a mutual promise to marry, where marriage is merely incident and not the end attained by the agreement. It is not deemed to be consideration, where there is some other consideration sufficient to support the oral agreement, in addition to marriage, such as agreement is not covered by the statute and oral evidence is advisable to prove the agreement. This agreement holds that if marriage is not the primary purpose of the agreement, but are rather secondary, then the agreement cannot be considered a contract based on the consideration of marriage. In other words, if primary purpose of the agreement is something else, such as exchange of service or goods, and then the parties agrees to include the marriage as additional benefit or incentive, then the agreement is not considered a contract based on the purpose or the promise of the marriage. Example, M agrees to build a house worth 500,000 for W if W will marry M. This must appear in writing to be enforceable unless M ratifies the agreement. The statute applies even when the promise to build the house is made by the third person to W. But a mutual promise to M and W to marry each other not need to be in writing. For the breach of mutual promise to marry, the injured party may prove the promise by the oral evidence in an action for the damages. Note that the law states no period for the performance unlike in the case of number 1. An oral mutual promise to marry may be proved by the payroll evidence even though the marriage is celebrated beyond 1 year. In short, if parties agree to marry and the celebration will take place more than 1 year from the date of the agreement can be enforceable even it's not in writing. Also called as anti-nuptial contracts are the agreement entered into the future spouses before the celebration of the marriage and in consideration thereof for the purpose of fixing the condition of their property related both with respect to their present and future property. Under Article 74 to 76 of the Family Code, donation propter nuptial or the donation by the reason of marriage are those which are made before its celebration and in consideration for the same and in favor of one or the both future spouses. Agreement for sales of goods, etc. at price not less than 500 unless if buyer accept and receive part of goods or pays some part of the purchase price at the time of the agreement, then the contract can be enforceable even it's not in writing. Another exemption applies to this is sales made by the auction. If the auctioneer makes an entry in their sales book at the time of the sales include the amount and kind of the property sold, the term of sale, the price, and the name of the purchaser, and the person whose account the sale is made, then the entry is considered as sufficient memorandum of the contract and can be used to enforce it. It is important to note that these exemptions are not absolute and may be subject to the interpretation and the variation depending on the specific facts and circumstances of the cases. as well as the applications law and regulation in the law where the contract was made. Example, S and B mutually promise to sell and buy a piano at the price of 12,000. This contract must be in writing to be enforceable against either parties unless there is a delivery or the partial or full payment, in which case is taken out of the operation of the statute of fraud, and the contract may be enforced even if it used or it was made orally.
On the lists of agreements that fall under the scope of the statute is the agreement for leasing for longer period than 1 year. To simply put it, if an immovable or a real property lasts longer than a year, it must be in writing in order to be enforceable. Now, let's have an example. If R agreed to lease his house for to 2 years, to E for 2 years, does it need to be in writing to be enforceable? Now, according to the statute, the answer is yes, because based on the example, the year of the lease exceeds the limit of longer than a year. So, for this to be enforceable, for this to be an enforceable one, it needs to be in writing, otherwise, it is unenforceable. Another agreement on the list is the agreement for the sale of a real property or of an interest therein. There is no regulation or law requiring a documented sale agreement. However, regardless of the price, a sale of a real agreement must be in writing to be enforceable. The reason for that is when a person or a third party claim rights over a certain piece of a real estate, they must produce or present any documented agreement as a proof prior to the protection of the parties inside the contract of sale. To further understand, let's have this illustration. S orally sold his land or his right or usufruct in said land to B. In this illustration, we can therefore conclude that the agreement is unenforceable because it must be in writing instead of having an agreement orally. Now, let's move on to the another illustration. S agreed in a private document to sell his land to B. The document was given to B who lost it. May B prove the agreement by oral evidence? According to the statute, the answer is yes. But since it is a sale of a real property, what is to be proved is not the oral but an but the written agreement. Though it is lost, B must present proof that the written agreement really existed. A lost agreement can be proved by a copy or by a recital of its content and some authentic document or by recollection of witnesses. This is based or according to the Rule 130 Rule of Court.
Next is representation as to credit of a third person. In an enforceable contract, the representation as to credit of a third person refers to a situation where one party, which is the promisor, makes a statement or representation about the creditworthiness or financial stability of a third person, which is not a party to the contract, to induce the other party, which is the promisee, to enter into the contract. However, due to the contract being unenforceable, the promisee cannot hold the promisor liable for any losses or damages resulting from the third person's failure to fulfill their credit obligations. Essentially, the promisee cannot rely on the representation as the credit of a third person in an enforceable contract to seek remedies or to hold the promisor accountable. For example, A is seeking loan from B. C represents to B that A is solvent and has a good credit reputation. Relying upon this representation, B extends his loan to A, who actually is insolvent. The representation of C, which was made to induce the extension of credit to A, must be in writing to be unenforceable. Now that's what representation as the credit of third person is all about. Moving on to the last but not the least, express trust concerning an immovable or any interest therein. Under Article 1443, a writ is necessary, not for purposes of validity, but to prove such trust. In an enforceable contract, Express trust concerning an immovable or any interest therein refers to trusts that are created explicitly and clearly regarding an immovable property or any rights or interests associated with it. However, due to the contract being unenforceable, the legal provisions and obligations related to the express trust may not be recognized or upheld by the courts or other relevant authorities. This means that the parties involved cannot rely as on the unenforceable contract to enforce or protect their rights or interests in the immovable property through the express trust arrangement. It is important to note that specific laws and regulations governing trust and property rights may vary across jurisdictions. To consulting a legal professional is advised in such situations. And that's all what you need to know about express trust concerning an immovable or any interest therein. And that is all for the agreement within the scope of the statutes of frauds. Let's move on to the next topic.
Let's move on to the test as to whether the promise is a collateral or an original one. As stated in the Statute of Frauds, a contract is unenforceable unless that contract or a note or a memorandum of that contract is in writing and signed with an authorized signature by the party to be charged. This statute of frauds defense is legally powerful but does carry some exceptions. Certain oral contracts can be enforced under the doctrine of promissory estoppel. However, this requires the plaintiff to prove that first, a promise exists. Second, the person who made the promise reasonably expected it would result in action on the part of the other party. And lastly, the promise created forbearance or reliance such that it must be enforced for justice to be served. A promise to pay for goods or service that will be provided a later time is known as the original promise. A promise to make payment for already provided goods and services is known as a collateral promise. Let's take the scenario where you wish to expand your company and a friend of yours agrees to cover all costs that go above your expansion budget. He refuses to pay though, leaving the business in serious debt and ultimately failing. Since the promise was not made in writing, you seek to sue on promissory estoppel, but the defendant disputes that a promise was never made. The defendant argues that the promise falls under the statute of frauds and is thus unenforceable without written agreement. This is when the distinction between original and collateral promise will come into play. So, original promises are exempt from the statute of frauds as a result of this distinction, and they are not required to be put in writing. The company cost would fall under the category of a collateral promise, which is not the case in this instance. Therefore, you would lose the case without a signed promise unless you can prove all required promissory estoppel elements.
Effect of statute of frauds where contract is divisible or indivisible. An indivisible contract means that it can be incapable to execute excluding as a whole. So if one part of the contract is illegal, then the whole contract is invalid. While the divisible contract is the legal aspect of the contract are enforceable due to the fact that they can be carried out independently. According to Article 1420, when the statute of frauds applies, whether a contract for the sale of chattels is severable or inseverable frequently determines whether it can be enforced. There are two possible answers to this question. First, the individual chattels may each sell for less than 500, but the total price of all sold chattels may equal or exceed this limit. If the sales are separate in this instance, the statute has no effect on any sales below the statutory limit. Even though separate chattels are sold, delivered is to be made in installment, and the price of each chattels is estimated separately. The statute is applies if the transaction is one wholesale and the price is at least 500. Second, according to the source, a portion of a sold lot of goods may be received and accepted or partially paid for. Does this meet the statute's requirements for other goods sold by the same parties? The response is contingent on whether or not the sales constitute a single transaction and yet receipt, acceptance, or partial payment that satisfies the statutes with regards to one chattel satisfies with the regard of all chattels sold under the same contract. According to Article 1420, even if a contract is divisible or not based primarily on the intention of the parties that appear by the terms of a contract and the certain of the specific case. Example, as the seller and B the buyer enter into the oral contract for the sale of two distinct articles at separate prices for each item. Item 1 for 400, item 2 for 500. The first one is the transaction is one entire sale. The receipt or payment by B of item 1 accept the agreement of the item 2 additionally out of the statute as well as the other way round. The standard is the equivalent where the cost of item 2 is under 500 yet the complete lot adds up to or surpasses 500. Certainly, the statute is not appropriate if the total is less than 500. 2. Sales are separate. The statute does not apply to item 1 of the contract when is for 400. Subsequently, the receipt by B of item 1 does not fulfill the statute as thing 2 for 500. If B acquires item 2, then parole evidence may be used to support both sales in terms of item 1. Statute does not apply and in terms of item 2, its receipt satisfies the statute.
Let's move on to Article 1404, which is all about unauthorized contracts. It is governed by Article 1317, Title 10 of the Civil Code of the Philippines. So what is unauthorized contracts? Unauthorized contracts, those entered in the name of another person by one who has been given no authority or legal representation or who has acted beyond his powers. So, for examples, X, representing himself as an agent of Y, sold Y's land to C. In this example, X is merely an extended hand of Y. Since Y is the principal, he or she is the legal owner of the land. So Y is having a legal transaction with Z. If X is not authorized by Y to sell Y's land, the contract becomes unenforceable, and Y and Z cannot demand from each other. The only way to make this contract enforceable is through ratification. So X needs the consent or authorization of Y to sell Y's land. Another example is X, agent of Y, sold Y's land to B in installment. A is only authorized to sell Y's land in cash. From the first example, the agent is not authorized to sell the land, while here, the agent is authorized. But there is a limitation, and here, in this example, X exceeds the limitation Y is given to X. Even though there is an authorization or consent of Y, which is to sell the land, but X didn't comply on what condition, then this contract falls under an enforceable contract.
Article 1405. Article 1405 provides the modes of ratification in order for the agreements in Article 1403 to paragraph number 2 to be ratified. The said agreements do not comply with the statute of frauds. Generally, verbal agreements are enough to make the contract binding and enforceable. But in this case, they are under the statute of frauds and it is a requirement that the contract must be in writing. They are under the scope of statute of fraud since the performance of the contract will take a year or more from the agreements of both parties. The said agreements does not have legal effect in law. In order for it to be binding and enforceable, it must be ratified. Now, what is ratification? Ratification is an act that cleanses all the defects of the contracts in order for it to be binding. A person must voluntarily approve
all the faults of the contract in order with his consent in order for it to be binding to him. There are two modes of ratification. The first one is failure to object. Failure to object is also a waiver. It also means that you are giving up the right for the contract to be enforceable. The second mode of ratification is accepting all the benefits of the contract. This will free the contract under the scope of the statute, and it will make the contracts not an executory contract anymore.
Article 1406 states that when an enforceable contract is governed by the statute of frauds and is in need of a public document to be registered in the Registry of Deeds, the rights under Article 1357 may be availed of by the parties. Take note that both parties must comply with the statute of frauds and there must be an agreement on both sides for this provision to be applied. If a contract of sale of immovable property is made orally, a party cannot compel the other to sign a public document because it infringes the provisions of the statute of fraud and makes this an unenforceable contract. This will be enforceable only when the contract has been ratified by the other party. A party can only compel the other for the effect of the agreement of the rendition in the form of a public document to have it notarized. In a similar state, a party cannot compel the other to execute a public document for a donation of real property when it is in a private instrument, because this voids the donation. In a scenario where A donated real property to B in a private instrument, Article 1357 does not apply, because a donation of real property must be in a public instrument. Once the contract is ratified, only then can the other party urge the latter to make it a public document. Similarly put, the contracts under Article 1406 must be valid and enforceable. If the contracts are enforceable under the statute of fraud and require public documents to be registered in the Registry of Deeds, the party can compel the other to execute the needed instruments. Public documents are only necessary for convenience, which compels both parties to perform the required acts.
As we all know, a contract where one party is incapacitated to give consent, it makes the contract voidable. However, in Article 1407, it is stated that in a contract where both parties are incapacitated or incapable of giving consent, then the contract is unenforceable. With that saying, in an enforceable contract, if the parent or guardian of either contracting parties or if one of them attain or regain capacity to give consent ratifies the contract, then it becomes voidable on the part of the party who did not ratify it. Meaning it is valid until it is annulled by the court, because ratification cleanses the contract from all its defects from the moment it was constituted. Then if the ratification is made by the parent or guardian of both contracting parties or if both of them attain or regain capacity to give consent, then the contract is validated and its validity retroacts from the moment it was first entered to. For instance, A and B entered into a contract. A is 17 years old and B is 16 years old. Since both of them are minors, as per Article 1407, they are both incapacitated to give consent, which makes the contract unenforceable. In that case, if the parent of A ratifies the contract, then it becomes voidable and is valid until it is annulled by the parent or guardian of B. But if the ratification is made by the parent or guardian of both A and B, then the contract is now validated and there will be retroactive effect from the moment the contract was first made. For example, the contract was made last May 5, then the contract will be valid starting from May 5.
Article 1408. Unenforceable contracts cannot be assailed by third persons. This is the right of the persons to assail an enforceable contract. Stranger to a voidable contract cannot bring an action to annul the same. Neither can they assail or question a contract because of its unenforceability. The benefit of the statute can only be claimed or waived by one who is a party or privy to the oral contract, not by a stranger. It is a personal defense. As the article implies, third person cannot be assailed or questioned on unenforceable contracts. To illustrate, S sells a parcel of land to B. The contract is oral. C binds himself in writing for the performance of B of his obligation to pay the purchase price. In action by S to recover the purchase price, C cannot assail the contract between S and B for being unenforceable under the statute of frauds. C is a stranger to the contract. This illustrates that C himself is a third person to an unenforceable contract. That's why C himself is a stranger to the contract.
The cases. The first case digest will now be discussed by Rina May Guerrero.
This is the intriguing case of Western Mindanao Company versus Medali. The related provision is the agreement within the scope of the statute of frauds that fall under the Article 1403 of Obligation and Contract, which is all about unenforceable contracts. The facts for this case was they obtained a right-of-way over the property on the 8th of September in the year of 1955, owned by Mr. Hernandez. 3 years later, the said property was purchased by Medale, the defendant. They allowed the continued use of the plaintiff to the road. When the defendant sent a notice for their intention to close the road, the plaintiff filed a complaint, hoping for the issuance of a writ of preliminary injunction to stop Medale from closing the road. The defendants filed a motion to dismiss the complaint for the ground that the claim in which the suit is founded is unenforceable under the provision of the Statute of Frauds and Special Law, and that the first page of the said wrote right-of-way agreement was not signed by both parties and the instrumental witnesses, and the second page is also not dated, and the signature of the plaintiff agents was not seen in the agreement. It is also not acknowledged before a person authorized to administer oaths. The plaintiff opposed the motion, stating that the agreement was not one of those agreements specified in the Statute of Frauds. Nevertheless, the trial granted the motion to dismiss. The plaintiff filed a motion of reconsideration for the said order, but it is not granted. The issue in this case is whether or not the right of way is enforceable in terms of the statute of frauds. Now, for the ruling of the case, the statute of frauds refers to the specific kinds of transaction and cannot apply to any that is not enumerated in the Article 1403 of Civil Code of Obligations and Contracts. An agreement creating an easement of right of way is not covered by the statute since it is not a sale of a real property or of an interest therein. The trial court therefore erred in dismissing the case upon the defendant's claim that the road right of way agreement in question is unenforceable under the statute of frauds.
Let's now move on to the second case, Rice et al. Versus Memji. Jose Memji, the dependent appellant, entered into a contract with Juan Benaventura Cabalsa for the repair of a house. Cabalsa undertook to furnish the necessary materials. Having no money and no credit, Cabalsa was unable to continue the purchase of the necessary lumber from Paul Rice, the plaintiff, who refused to sell without payment in advance. Jose Memji told he would stand good for the amount of lumber needed in the repair of his house. Paul Rice brought action to recover the unpaid balance of the purchase price of lumber delivered. Was the promise of the defendant unenforceable, not being in writing? No. The promise of the defendant was not collateral but an unoriginal one, and therefore did not have to be in writing. The circumstances disclosed that the credit for the lumber was extended by the plaintiff solely and exclusively to the defendant under a verbal agreement he had with him. Memji admitted on the stand that Cabalsa had no commercial, credit, or standing in the community, and it appeared that Rice, after investigation, absolutely refused to extend Cabalsa any credit whatsoever, and that defendant was well aware of the fact, and that he examined every invoice which by agreement was submitted to him, and that no lumber was delivered without his approval.
The third case, First Philippine International Bank versus Court Appeals, General Register Number 115849 on January 24, 1996. The case of First Philippine International Bank versus Court of Appeals involves the acquisition of 6 parcels of land by the bank. Demetrio Demetrian and Jose Hanolo expressed their interest in purchasing the property and made a formal offer through a letter. The parties engaged in a series of letters containing of offers, counter-offers, and acceptance. However, the bank's conservator was replaced and the new conservator refused to acknowledge the agreement, advertising the land for sale instead. The plaintiffs filed a lawsuit seeking specific performance and damages. A motion to intervene by Henry L. was denied by the trial court. The trial court argues that a valid and perfected contract of sales existed between the parties based on the requisites of consent, certain object, the land, and the cost of obligation. The contract is enforceable under the statute of frauds, and the bank's letter and the plaintiff's acceptance constitute a sufficient memorandum of the agreement. The court also finds no evidence of the conservator repudiating the contract at the time of its perfection.
And that's all for our video about unenforceable contracts.